Hi, I'm firearms attorney Gilbert Ambler, and we're back today to talk about how very frequently the anti-gun crowd, and I'm going to include the government in that as the anti-gun crowd, very frequently they try to claim the moral high ground in firearms litigation, claiming that theirs is the side of safety and that people that are pro-firearms and pro-freedom don't care about safety. We're going to talk about how that claiming of the moral high ground has apparently pissed off at least one federal judge. And I'll tell you right now, if there's one thing you don't want to do when litigating a case, and every lawyer knows this, you don't want to upset the judge. Before we dive into this subject, however, if you have not yet hit that subscribe button, what are you waiting for? Hit that subscribe button, like, comment with your thoughts, share with your friends. That way you and your friends can keep getting this important Second Amendment related content. The case that we're talking about, and we actually previously discussed this case on this channel, was the Illinois public transit case. And we can link in the comments below or in the description below to that prior video. But in this case, and I'll just refresh your recollection, at the end of August 2024, a federal judge in Illinois ruled that it was unconstitutional as applied to the named plaintiffs in that case, to 4 people, to prevent them from carrying concealed firearms for the purpose of self-defense on public transportation in Illinois. Fast forward a couple of days, and the government files a motion to stay. Essentially, they're appealing the ruling, and what they're asking for the judge's order allowing those 4 men to carry, those 4 named plaintiffs to carry. They're asking for that order not to take effect, not to allow them to begin carrying while the appeal goes forwards. The problem for the government came when, in their motion to stay, they dropped the line. And the line went something like this, and we'll post it up on screen so that you can see it. The line said that the potential safety concerns of the court's order are highlighted by a recent mass shooting that took place on the blue line, and that this shooting occurred only 4 days after the court's prior order in this case, and 4 people were apparently murdered in that shooting. Well, essentially, with that line, what the government was doing was blaming the court for the murder that occurred on the blue line. They were saying that the judge was directly responsible. Because the judge allowed people to carry firearms for self-defense, he was responsible. It showed the safety concerns that those people could be murdering people. And the judge, as he should have, took offense to this. And I'll tell you, I can't tell you how many times I've seen that moral high ground taken where the anti-gun side claims that they're responsible for safety and that if you allow people to carry guns, it's going to result in murder. Well, the judge said, no, in this case. Instead, he has scheduled a telephonic hearing. He scheduled that hearing for October. And what he wants to talk about is Federal Rule of Civil Procedure 11B. Because Federal Rule of Civil Procedure 11B says that any attorney who signs on any filing to the court is attesting. They're saying that they are reasonably certain that what they have put in that filing is true. And so the judge wants to know, he wants to hear from the people on the behalf of the government who filed this argument. He wants to hear from them what reasonable inquiry they did to show that they believed it's true that his order is somehow related to this murder that took place. Essentially, what he's going to be asking them is, do you know whether the murderer in this situation even had a concealed handgun permit? Was even eligible to carry a concealed weapon? Do you know whether he carried that concealed handgun onto the blue line for purposes of self-defense? How was he defending himself when he shot 4 people which were apparently sleeping, according to news articles, at the time he shot them? And of course, we all know this. This murderer, the person who came on and shot sleeping homeless people, was not a self-defender, was very likely not licensed to carry the firearm, and furthermore, even laws banning him from carrying the firearms, which, keep in mind, the judge's order allowing carry applied only to the 4 named plaintiffs. And because this individual was not one of the 4 named plaintiffs, he wasn't allowed to carry on the blue line at this time. But even if everyone was allowed to carry for purposes of self-defense, he probably would not have cared about laws about self-defense because he was there to commit murder. Likewise, if no one was allowed to carry, he probably would have taken the exact same action. And so, of course, and I try to remind judges of this. In fact, I remind my own family of this. When it comes to the moral superiority of who wants safety, Both sides want to feel the same thing. People that hate guns, they want to feel safe. People that like guns, we want to feel safe. We want guns because we recognize that it can help us stay safe. And that's a great example here. I would argue the very opposite is true, that by allowing people to carry concealed firearms for self-defense on public transportation, you give them the tools necessary to defend themselves against crazed murderers. Anyway, it will be very interesting to see how this telephonic hearing plays out and whether the attorneys that tried to blame the judge for the mass shooting and the murder that occurred, whether they can show that there was any truth behind their assertions. If you enjoyed this content, hit that like button, subscribe to us, share with your friends. Until next time.